So, friends, we are today. I am going to talk about the adjudication proceedings because nowadays there are a lot of adjudication notices are issued by the registrar of companies across India by various states register of companies, and they are finding the faults of the company non-compliance of the provisions. So let us discuss about introductions and various defaults and procedures of our adjudication, effective way of attending and penalties and repeated defaults and also appeal. Uh, we have to see that adjudications not defined in Companies Act 2013 and penalties also not defined in Companies Act 2013. Adjudication of penalties, determination of penalty for breach of any provisions of the Companies Act 2013. Precisely, we see that adjudication of penalties is nothing but determination of penalty for breach of any provisions of Companies Act 2013. Adjudication of penalties can be determination of penalties judicial as a court for breach of any provisions of the Companies Act, and what are the ways for adjudication proceedings will happen. One is the inspection, investigation, inquiry, suyamoto, and any complaint from stakeholders. Means in within the director's dispute or shareholder dispute that the same will be available. Let us discuss about that various defaults. Section 4 about the reservation of name. In case of the name has been resemblance applied for punishing a wrong or incorrect information, it is a default. Section 10A is nothing but INC to commencement of business not done by the company after the incorporation of the company. If there is any default made in complying with the requirements of this section, then that adjudication proceedings will happen. Section 12 is nothing but the register office. Register office compliance is nothing but default in complying with the provision of the section 12. Section 12 is major problem with the companies is they have incorporated the company in the register office form. They have filed the register office situation of the register office form and everything. But after that, what happened? They are vacating the register office and not filing the new address. The major cases where the registrar will send any notices or anything, it will return back. Then the registrar will take the action against the company and its officers. The alteration of MOA AOA has to be noted in every copy of the MOA. What are the alterations? One is whether it's the shifting of registrar is one state to another state, or change of object class, or change of the name of the company, or increase in authorized capital or reduction in authorized capital, like that. Articles, there are a lot of amendments are there. Each amendment we have to mention in the articles of association, noted so that people can understand how the company has changes has happened by the shareholders from time to time. Means nominee directors, board of issue, or retrenchment sections, retrenchment classes, or the women directors, or managing directors, and quorum for board meetings or yeah, annual general meetings, everything we go to any modification we have to mention, and the same has to be noted in the pursuant to section pursuant to the EGM of the extraordinary general meeting or annual general meeting of the company. The company has amended the articles of the class, so and so class, and the revised class we have to mention in the noting. Section 17 is failure to send agreement MOA articles requested by members within 7 days. Any member requested that memorandum or articles we have to send within 7 days. Nowadays, but any member he can even download from the Ministry of Corporate Affairs wherein the memorandum and articles are there. Companies which incorporated prior to the 2006, it is very difficult to get, so that they have to obtain from company only. Section 15. Every alteration, okay. Now another thing is also there. Director's report also we have to see that how director's report have to be mentioned. and DIN number has to be mentioned in all the documents. Section 158 is there. If there is any default, then there is a adjudication proceedings will happen. Section 33 also there, company does not provide the abridged prospectus with a form for purchase of any securities of a company. Section 39(5), company does not file any return of allotment, discharge within the time of allotment, and make defaulted refund of the application money to the subscriber. There is no such provision in the 1956 Act. We can retain the share application money. Now the Companies Act, within 60 days we have to allot the shares. If they are not allotting the shares, we have to return back the money to the subscriber or proposed shareholders. Section 42 is the private placement, where we have to make some return of allotment within 50 days from the date of allotment. And Section 42 is not, and also the private placement also separate bank account we have to make. And if the bank account are not opened and kept there before allotment, it is also a violation. And 4210, if a company makes an offer or accept monies in contravention of the section, then it is our default. Section 53 is also, the company is not supposed to issue a shares at a discount except ESOP. Section 56 is default in complying with the provisions of relating to transfer and transmission of securities. And the charges also there, if the company has to make default in, if they default in section 77, then it is a violation of the Companies Act 2000. Like every section, there is a some compliance procedure is there. If the company is not complying, then the adjudication officers will look into the same, and default will be there. If company has created a charge, then the charge has been discharged by the company, and the same has been mentioned in the balance sheet. There is no long term loan or other things, but the company not able to file the satisfactory charge, then it is a default in complying the process of the Companies Act process. So these are the some of the defaults we come across with the adjudication proceedings. And a lot of everywhere the provisions are mentioned in the non-appointment of the women directors, non-appointment of the independent directors, or non-appointment of the company's directors is also there, or default in conducting the AGM, default in filing the financials. So, like lot of defaults are there. The company, the registrar of companies are taking out and digging out and issuing the notices and appearing the companies to come there for appearance and express the views and put the penalties there. Let us discuss how finding a first job is the registrar of companies finding out details committed under the Companies Act 2013. Issue of so-called notice to the company in the answers details a violation of any provisions Companies Act 2013. So while issuing the so-called notice, they have to ask for the reply from the company. Why the violation happened or not happened, you have to please explain. In one case, I have seen that they have issued the so-called notices, and also the adjudication officer have even called for the attendance of the professionals is nothing but the 134 3B. Section 134 3B is nothing but director's reports of certain details to be mentioned in the director's report, which was not mentioned. The during the inspection, the inspection inspecting officer found that director's report not mentioning about the venue of the meeting and the time of the meeting not mentioned in the director's report. But later on, 134 3B, it was not mentioned. Only the number of meetings only we have to mention. But we have mentioned the company has mentioned about the number of date of the meetings and number of directors, total number of attendance of the company, and the number of members attended the meeting. They have mentioned. The another is the so-called notice, section 92, subsection 1 and was 137 subsection 1 or 2. One of 2 is default. Whenever default is happening, is nothing but non-filing of the financials with the companies, registrar of companies. If they found if they are issuing the notices by adjudication officer, then 30 days within if the default has been rectified either prior to the prior to or within 30 days of the issue of notice by the adjudication, then the penalties shall be no penalties shall be imposed. Only this is the only provisions exemption for the companies in case they have fulfilled, they have filed the returns, fine MGT 7A and MGT 7 or AOC 4. They can file even before the issue of notice or 30 days from the issue of the notice. Then there is no default, then no penalty will be issued. In case if the after issuing notice after the 30 days, if they are issuing, then they are supposed to review the penalties in that case. Now, issue of notice of inquiry and fixing the date of hearing AO for the company and the officers. In case of the company, the so cost rate is not, the replies are not sufficient, or convinced by satisfactory answers are not provided by the company, then what will happen? Then the AO can, adjudication officer can issue the notice of inquiry and fixing the date for hearing by AO for the company and the officers. So power of AO to summon and enforce attendance and to order for evidence of the documents. So during they can even summon and enforce the attendance and order for evidence of documents. So on the date of the hearing, we have to go either the company directors or company officials they can go, or the professional engage the professional they can go there. They have to give the memorandum of appearance, or the directors are going. They have to bring their board resolution for attending the adjudication proceedings. After hearing the parties, AO can pass the orders. In case summons are issued and enforce the attendance of the order, then the AO, and in case the summons are issued on the people, the officials not turned up or professionals not turned up on the date of the day without even asking for the adjournment proceedings, AO can pass the ex parte order in case of any person fails to appear. So hearing the parties at on the date of the the date of the hearing, the AO can hear the parties view and view the full uh, opportunity to be heard by the parties, so that so that they can hear and if they are satisfied, then they can drop the proceeding. If they are not satisfied, then they can impose the penalties. Passing of order by adjudication penalties by the adjudication officers. AO order should be dated and signed by the AO. Communicating the order to the concerned parties means companies and its officers, and also by central government by AO. Communicating the order is nothing but if the managing director is there, then only the managing directors and the company. If there is no managing director, all the directors be in issued communicate the order to all the directors. Lesser penalties for OPC or small companies or startup or producer companies. There is a provision in the Companies Act for lesser penalties for OPC or small companies or startup or producer companies. One of the provisions specifies such provisions. Every provision, there is some uh, penal provisions are there. Only half of the penalties will be imposed to them to the small companies and OPCs and startup or producer companies. Repeated defaults. This is another area where commit such defaults within a period of 3 years. Penalty already imposed by AO or regional directors. Second or subsequent default penalty provided equal to or twice the amount of penalty provided for such defaults order under the relevant provisions of the Act. If suppose that equal or twice the amount, they are having a power to impose the penalty. Suppose 3 lakhs means they can impose up to 6 lakhs for the repeated defaults. So, in case of the adjudication authorities, adjudication officer has issued the order, then within 60 days, the company can go for appeal to the regional directors. Regional directors, on seeing the merit of the appeal. He may or may not waive the or reduce the penalties based on the case to case basis. So it all depends upon how we are presenting to the regional directors for the same. So the once the appeal is decided, then we are bound by that appeal decision of the regional directors, and we have to pay the fees to the Ministry of Corporate Affairs. We can discuss the regional directors appeal in the next video in details. Thank you very much.